Welcome to the deep dive. Today, we're taking a deep, fascinating cut into a single, profound legal puzzle, a classic contract case that really teaches us the devastating consequence of words failing us. We are diving into the 1864 ruling of Raffles v. Wichelhaus. It's a case involving Cotton, Bombay, and get this, two ships that share the exact same name. Our mission here is to gain actionable knowledge quickly. We'll do this by dissecting how a written, apparently sound contract can suddenly just evaporate, simply because of a fact existing entirely outside of the document itself. This is really the masterclass in what's called latent ambiguity. And for you, the learner, this is the shortcut to understanding when a deal is, well, no deal at all.
Exactly. And to solve this riddle, we really have to follow a precise analytical path. We have to start with the foundational requirement for any contract to even exist, which is mutual assent, or consensus ad idem, as the lawyers say. Once we confirm that requirement, we then have to look at the necessary context, like, why do courts usually ignore facts outside the contract? And only then can we really dissect the specific exception, known as latent ambiguity, element by element. We'll use a structured analysis model for maximum clarity.
Okay, let's unpack this core idea first. Forget the written paper for just a second. What is the absolute fundamental, non-negotiable requirement for a binding contract to exist in common law?
It's the meeting of the minds' mutual assent. Legally, that's consensus ad idem. Basically, if the parties didn't agree on the same thing, there's simply no deal. This rule has three essential elements that must be met. First, the parties must objectively show an intent to contract. Second, there have to be a clear offer and acceptance. And third, critically, they must intend to contract concerning the same subject matter. If you were thinking apples and I was thinking oranges, well, the paper we signed doesn't really matter.
Okay, that makes perfect sense for, say, an oral contract. But this case, it involves a written contract for cotton. Historically, courts really protect the sanctity of the written word, right? So if the contract's clear on its face, why should a court ever allow outside facts to just creep in and destroy it?
That's a crucial point, and it brings us straight to the parole evidence rule. Generally, this rule says that once parties put their agreement into a final written contract, you usually can't bring in prior or contemporaneous outside evidence, that's the parole evidence, to contradict or vary or add to the clear written terms. The whole point of the rule is to provide certainty. The writing should, ideally, speak for itself.
So if I sign a contract to buy, let's say, a blue car, I can't later just claim I secretly meant a red one. The parole evidence rule protects the word blue written in the contract.
Exactly right. But latent ambiguity is kind of the exception that proves the rule, or maybe swallows it sometimes. It basically says, look, we aren't using this outside evidence to contradict the written terms themselves. We're using the outside evidence to show that the written terms were fatally flawed from the start, because they didn't actually mean the same thing to both parties. It shows there was never really a contract to begin with. A true meeting of the minds never happened.
Okay, that sets the stage perfectly for our case study then. Let's analyze Raffles v. Wichelhaus. This provides the ultimate test for this failure of mutual assent. Let's start modeling our legal analysis. First, what are the legally dispositive facts?
Right. So you had the plaintiff, Raffles, and the defendants, Wichelhaus. They entered into a contract. It was for the sale of 125 bales of Surat cotton. And the contract described the goods as to arrive ex-peerless from Bombay. Now, here's the surprising fact that came out later. There were two separate ships, named the Peerless. Both had sailed from Bombay. One arrived in October. The other arrived 2 months later, in December. The seller, Raffles, offered the cotton from the December ship, but the buyer, Wichelhaus, refused it. He claimed he only ever intended to buy the cotton from the October ship.
Wow. I mean, what are the odds? Two ships, same name, same route, same year. It almost sounds like something out of a comedy. So what was the core legal issue that the court had to sort out here?
Well, the precise legal question was this. Did the ambiguity that arose from having two identical peerless ships mean that the parties actually failed to achieve consensus ad idem? And if so, did that failure prevent the formation of a binding contract altogether? Was this a genuine mistake about the subject matter itself, or was it just a simple breach, like a late delivery?
Okay, so what rule of law did the court apply to figure this out? Can you state the full black letter rule and maybe break it down into its testable elements for us?
Sure. The court applied the rule governing latent ambiguity. That's the exception to the parole evidence rule we just talked about. The black letter rule goes like this. Parole evidence, so extrinsic evidence, is admissible to clarify a latent ambiguity when a written contract appears clear on its face. But external facts reveal that a key material term actually has two or more reasonable meanings, and the parties intended different meanings. And this rule has three distinct elements we need to test. One, the contract has to be facially valid. That means clear written terms on the surface. Two, external facts must reveal two distinct reasonable meanings for a material term. This is the latent ambiguity itself. And three, the parties must have actually intended different meanings when they made the contract.
Thank you. That's very clear. Now for the court's elemental analysis. Let's walk through this step by step, element by element. How did the court apply the first element, the requirement that the contract be facially valid?
Right. The court found this one was met pretty easily. The initial complaint, the declaration, it laid out the written agreement clearly. Sale of 125 bales of cotton, ex peerless, at a specified price. Critically, there were no obvious errors, no omissions, no vagueness you could see just by looking at the document itself. On its face, it looked perfectly sound.
Understood, but wait a minute. If the contract was so clear on its face, why didn't the court just rule for the seller, Raffles? Why not just force the buyer to accept the December cotton and maybe treat this as, I don't know, a simple case of delayed delivery?
That's the absolute key distinction here. If the term peerless had only one possible meaning, then yes, it would likely be a breach case, maybe damages for delay, something like that. But the defense argued successfully that the term actually had two reasonable meanings in this context. And that leads us directly to the second element, where external facts reveal two distinct meanings for a material term. This is the moment the latent ambiguity pops up. The defense counsel, Mellish, he really hammered this point. He argued that the evidence outside the contract, the simple fact that two ships named Peerless sailed from Bombay, made the term peerless inherently ambiguous, and the court agreed. They found that this external fact rendered the key term ambiguous, even though the contract itself never mentioned a specific sailing date. The cotton shipment was identified by the ship's name, and that name, it turned out, was uncertain.
This gets really interesting now. Because the plaintiff's lawyer, Millward, he argued back, he said the specific ship didn't actually matter, only that the cotton arrived on a ship called the Peerless.
Mhm.
How did the judges react to that argument? The idea that the ship itself was just an irrelevant detail.
Oh, they rejected it. Forcefully. Chief Baron Pollock and Baron Martin, they challenged Millward directly on this. They basically confirmed that the identity of the ship is a material term. Why? Because it's used to identify the specific goods intended to be sold. Pollock, the chief baron, even offered an analogy. He said, look, it's like contracting for wine from a specific estate in France or Spain, but oops, there happen to be two estates with the exact same name. If the parties meant different estates, well, there's no deal, because they weren't actually talking about the same specific product. They didn't agree on the thing being sold.
Okay, so the court established the ship's identity was material, and the external facts created this hidden, latent ambiguity. So that opens the door to the final step. Let's look at the third element. Did the parties actually intend different meanings for that material, ambiguous term, peerless?
Yes, they did. The buyer's response, their plea, explicitly stated they intended the Peerless that sailed in October. They were likely expecting an earlier delivery, maybe for price reasons or market timing. Meanwhile, the seller was clearly offering the cotton from the December Peerless. So, because the material term peerless was ambiguous, and the parties held demonstrably different subjective intentions about the goods identified by that term, well, the final element of latent ambiguity was met.
Right, and after analyzing all those elements, it looks clear on its face, but external facts make it ambiguous, and the parties genuinely meant different things. What was the court's final conclusion?
The court essentially stopped the defense lawyer mid-argument. They said, we get it. They agreed that because of this latent ambiguity and the clearly different intentions, there was, and I quote, no consensus ad item, and therefore no binding contract. Judgment was entered for the defendants, Wichelhaus. The contract wasn't just breached, it was void. It never truly existed because the minds never actually met on the subject matter.
Okay, the rule is now much clearer. If a latent ambiguity destroys that essential mutual assent, the contract itself never existed. It's void from the start. Let's try a visceral hypothetical now, just to really hammer home the limits of this principle and make it unforgettable. Imagine a contract. It's for 10 casks of port wine, ex Santa Maria from Portugal. Okay, simple enough. But later, we find out there are actually two ships named Santa Maria sailing from Portugal 2 months apart. Now here's the twist. The first ship carries absolutely top-notch, high-quality vintage port. The second ship, well, during its voyage, the 10 casks of wine completely soured. It's basically vinegar now.
Right. What's fascinating here is how the ambiguity acts almost like a key, unlocking other evidence. If the contract had just vaguely said 10 casks of port, The quality difference, vintage versus vinegar, might just lead to a standard breach of warranty claim, right? This isn't the quality I expected. But because the ship name, our peerless parallel, the Santa Maria, is latently ambiguous, it allows us to bring in that quality difference as evidence of the parties' different intentions. You could argue the buyer intended the voyage identified by the high-quality wine, the earlier ship, while the seller was maybe trying to pass off the voyage identified by the spoiled goods, the later ship. The Raffles rule applies perfectly. The ambiguity in the ship's name prevents a meeting of the minds on the specific thing being contracted for, which is the wine as identified by its specific voyage. So the contract is void. It just never existed. The seller can't force the buyer to take the vinegar.
Okay, but let's flip that scenario slightly. What if, upon discovering the two Santa Maria ships, the seller, like Raffles in the original case, could actually prove that the buyer knew the first ship, the one with the good vintage port, was already fully booked or sold out? And maybe that any reasonable merchant in their position would have known they were definitely contracting for the second shipment, the one that unfortunately soured. Would the contract still be void then?
Now that changes the analysis quite a bit, because if it could be shown that one party knew, or really should have known, what the other party intended, well, courts often shift away from the purely subjective view and look at the objective standard. If the buyer in your hypothetical knew the first ship was impossible, then arguably by signing the contract naming Santa Maria, he objectively manifested assent to the only available option, the second ship, even if it turned out badly. In that scenario, the latent ambiguity defense might be negated. The court might say, look, you knew what you were getting into, or you should have known, and the contract could be held valid. The core of the Raffles ruling really relies on the idea that both parties' interpretations of the ambiguous term are equally reasonable and genuinely held.
Got it. So the key lesson is the latent ambiguity has to be genuinely hidden, or at least not obvious to one party, based on what the other reasonably intended. And both interpretations need to be plausible for the agreement to just completely fall apart. #tag exam framework synthesis. That was a really rigorous look at how these hidden ambiguities in material terms can completely destroy a contract if they secretly mean two different things to the parties involved. So thinking about the learner, the person trying to apply this, what's the step-by-step diagnostic checklist we can pull together from the Raffles rule? How can someone spot and resolve latent ambiguity when they see it in a contract problem, say, on an exam?
Okay, yeah, this provides a really actionable tool for issue spotting and then doing a structured analysis. When you face a potential contract problem, you can follow this framework. Step 1. Check for facial validity. First, just read the contract itself. Are the terms clear and unambiguous right there on the written page? If not, if it's obviously confusing on its face, that's patent ambiguity, which is a slightly different issue. Step 2. Identify external facts. Look beyond the document. Scan the surrounding circumstances, the background information. Do any facts outside the written contract suggest there might be a hidden problem? Step 3. Spot the latent ambiguity. Does one of those external facts cause a material term in the contract, like a name, a model number, a specific location, to suddenly have two equally reasonable interpretations, like our two peerless ships or the two Santa Marias? Step 4. Confirm lack of assent. Now, and only after you've found that ambiguity, you investigate. Did the parties subjectively intend different meanings for that specific ambiguous term when they made the deal? And step 5. Apply the rule. If that ambiguity genuinely prevented mutual assent, no consensus ad item, then the court will admit the parole evidence, the outside facts, to prove that the fundamental requirement for contract formation was never actually met. And the absolute key takeaway is this. Latent ambiguity, when proven, doesn't just lead to a breach claim, it makes the contract void from the very beginning.
That was indeed a deep and rigorous analysis of mutual assent and its hidden pitfalls. We've successfully determined that, yes, having two ships with the same name sailing at different times can create a latent ambiguity potent enough to prevent the very formation of contract for something like cotton.
Absolutely. And if we can this to the bigger picture, it really raises an interesting final question for you, the listener, to consider. Think about this. What if both parties in Raffles, both the buyer and the seller, had later claimed they both intended the October ship, even though factually, the seller was only offering cotton from the December shipment when the lawsuit started? Would the latent ambiguity, the existence of the two ships, still allow the contract to be voided because of the potential for confusion? Or would their apparent expressed agreement on the same ship, the October one, transform the issue? Would it no longer be about contract formation, but simply become a straightforward question of breach by the seller for failing to deliver the October cotton? It makes you think about that tension between objective agreement and subjective intent, something for you to mull over.